morning, everyone, and thanks for coming. I'm pleasure to introduce Elizabeth momentarily, but I wanted to give a quick opening remarks and let people continue to straggle in. Well, first, thank you to everyone for coming, and I have some prepared remarks, but I wanted to tell a story about what happened yesterday with me. I was at the barber, and I was telling, my wife was like, "You need to be presentable," and so, I got a haircut, and I'm at the barber, and I was telling him about this conference, and we're in a bit of a Washington bubble here. We've got a lot of policy experts coming up, but it's always good to talk to real people in their everyday life about the policy issues that we're talking about here. And I told him we're talking about personalized pricing, and he said, "Oh, is that the thing that happened at Wendy's?" And yeah, and it happens a lot more than you probably realize. And then we had a long conversation, and the three things stood out to me. The first was that the first thing he said was, "That's not fair. That's not right." And I thought that was interesting. That's kind of an interesting reaction, that not only did he have something that had some legal significance to it, this is an unfair business practice, but also there was a moral element to him of that it was also wrong. That stood out to me. We continue to talk about algorithmic pricing in your housing prices, your food prices, your and other products, and also for labor, for wages in the gig economy. And he said, "What? Let me. I have it written down. Do they want us to be like slaves?" That was his reaction to that. Which, I mean, that's a. And I've been thinking about that.
For those who apparently don't read the same press, didn't it happen at Wendy's?
So there was personalized pricing at Wendy's, where Wendy's was giving different people that go through the drive-through different prices. But we were talking about algorithms setting prices for housing, for airlines, for wages in the gig economy. And he said, "Do they want us to be like slaves?" And I've been thinking about that all, last night and this morning, and that had me thinking about some other questions. Why was that his reaction? Was it the powerlessness in the position, the feeling of being, dominated by these companies? Is that why he said it? Or is it about, like, his rights as a citizen being subordinated to the rights of an algorithm or a corporation? And that to me feels particularly relevant because big tech is making arguments like that in court, that their algorithms have speech rights. And lastly, he said he made a prediction about technology, and he said he expects young people to be more comfortable rejecting technology in the future. And his example was when he was younger, his family would like to take pictures. Taking pictures was kind of a joyful occasion for him and his family to do it together. And now he sees kids tell their parents to get that phone out of my face when they're taking pictures of them at home. The home is not where they want to see a phone because it's such a part of their daily lives, was his explanation. And that raises another question for me, which is, will our children have a choice to reject technology? My kids are required to have an app to do their math homework sometimes. I was listening to a podcast with Werner Herzog, and he was saying he doesn't have a phone, but he had to get one because he needed an app to get out of the garage at work. But he otherwise turns it off. So, will there be a choice? And so, that was my way of delaying to get my actual remarks. But no, that was. I've been thinking about that as a way to frame our conversation today, the questions in the back of my mind from my time at the barber. But it's wonderful to see everyone here today for a full day of thoughtful discussion. We have a terrific program. We've got panels on algorithmic collusion, surveillance, pricing, data brokers, digital advertising. And to kick things off, I'm honored to introduce our morning keynote speaker, Elizabeth Odette, Assistant Attorney General in the Consumer Wage and Antitrust Division of the Minnesota Attorney General's Office. She also serves as chair of the Antitrust Task Force at the National Association of Attorneys General, where she has helped shape the enforcement agenda for attorneys general across the country. Before that, she was in private practice for 15 years, working on some of the most significant antitrust class actions in recent memory. We're thrilled to have her, and I just think that the view from the state AGs is just such a unique and valuable perspective right now, just with everything going on when it comes to democracy and rule of law. And so with that, please give Elizabeth a warm welcome.
Thank you. Before I begin, I'll just issue a quick disclaimer that my remarks are my own and not of the Office of the Minnesota Attorney General or the National Association of Attorneys General. But with that, I am very excited to be here to kick off the Capitol Forum Tech Conference for 2025. First, it is incredibly important to be here discussing, debating, and analyzing how technology is shaping the industries and markets that have developed specifically devoted to technology products and services. But the tech industry is a bit of a misnomer because there are a myriad of ways in which technology has shaped and influenced other more traditional industries and markets, as was just illuminated. Technology doesn't just dominate our lives in ways that we couldn't have imagined 30 years ago. Discussion and debate about technology, electronic data, and AI is in the public discourse. Every day, people without law and economics degrees are discussing, debating, and tracking on their social media and news feeds how they see tech impacting them and how they feel about it. Well, it may be in their news feeds if the algorithms they use will have them think they are clicking on it. That means that those of us deep in the weeds on it have a pretty big responsibility. And people are watching and paying attention. We need smart people thinking about, analyzing, debating, and yes, litigating the issues. Our legal system is designed to navigate, and if necessary, make determinations about sticky legal issues. Most of the time, businesses want to be able to navigate legal risks without being in court, but there are many outstanding questions when trying to assess those risks. Do enforcement frameworks need to be updated to keep pace with technology's complexity? What tools and metrics should regulators use to assess things such as market dominance in digital ecosystems? Is not enough or too much being done to ensure innovation can thrive while preventing monopolistic behavior that stifles competition? Is not enough or too much being done to protect consumer tech interaction and use of consumer data? Given that I'm the National Association of Attorneys General Antitrust Task Force Chair, representing state attorney generals, antitrust enforcers across the country, I thought I would use my time to share with you all some examples of what state attorneys general are doing in tech enforcement, why states should be enforcing in these spaces despite often there being nationwide impact, and then I'll end with some examples of what state legislatures and local municipalities have passed or are considering to address some of their concerns about the use of technology. So starting with the what. On digital advertising, it is certainly worth mentioning that 34 states and territories are collectively involved in two separate Google ad tech cases. The Department of Justice and certain states in the Eastern District of Virginia action are in a 2-week remedy trial right now. And the Texas Attorney General led action in the Eastern District of Texas. The status is trial ready and stayed pending the outcome of the Eastern District of Virginia action. One important thing to note regarding these two separate actions is the Eastern District of Texas case led by the Texas Attorney General was the first to be filed. Unfortunately, the case's progress was delayed while the kinks of the State Antitrust Enforcement Venue Act were worked out. The Venue Act was passed in a larger budget bill at the end of 2022. This leapfrogging of federal enforcer-led matter over a state-led matter, as happened in the Google ad tech matters, is unlikely to occur in the future. State enforcers with tech matters, or other matters generally, are now on equal footing with federal enforcers in filing in the venue of their choosing, with only the risk of facing the standard venue challenges and not being transferred into a multi-district litigation with private plaintiffs. Case in point, RealPage. On algorithmic pricing, which we can look forward to hearing about more from our first panel, there are several cases against RealPage and various landlords. And I'd just like to focus on the timeline of the cases and how one might want to consider this from a risk management perspective in considering potential risk of state enforcement action. In the fall of 2022, private plaintiffs brought a class action against RealPage and certain landlords in the Middle District of Tennessee and survived a motion to dismiss in 2023. The local attorney general here in the District of Columbia filed the first government action on November 1st, 2023. The Arizona Attorney General followed suit in February 2024. In late 2024 and early 2025, the Department of Justice and 10 states sued RealPage and certain landlords in the Middle District of North Carolina. After initially being a part of the federal and state case, Washington's Attorney General filed suit in Washington State Court in April of this year. Also in April, the New Jersey Attorney General filed suit in New Jersey. And then in July, the Kentucky Attorney General filed suit in Kentucky. And just 12 days ago, Nevada's Attorney General filed a lawsuit and a consent judgment with RealPage on the same day in Nevada. Now, with the State Antitrust Enforcement Venue Act in place, these states, if during their investigation determine that the evidence is strong of local harm and supports state claims, and they have the resources to devote to a solo action and it is a priority, they can bring those cases before a court in the state in which the alleged harm is occurring. Companies must account for this multi-jurisdictional risk when assessing whether the use of their technology tools is above board. Settlements reached by certain states previously mentioned and the Department of Justice with some landlords are anticipated to bring immediate results to local markets. While there are many decisions yet to be reached, these early results are a promising sign for enforcers. An additional tech case involving states is the case that the Federal Trade Commission and 19 states and territories brought against Amazon in September 2023 for illegally maintaining monopolies in online retail in two markets: the online superstore market that serves shoppers and the market for online marketplace services purchased by sellers. I would also argue that the lawsuits brought by the Federal Trade Commission in certain states against Deere and the Department of Justice and certain states against AgriStats, while in the agriculture space, are tech cases at heart. With the first dealing with the technology in Deere products that the complaint alleges currently impedes equipment owners from being able to fix their own equipment. And the second, alleging that AgriStats' collection and organization of massive amounts of data and information of certain dominant meat processor competitors that is exchanged and exclusively amongst and for those competitors is anti-competitive. Now to the why. Why are state enforcers in antitrust and consumer protection laws looking in this space and enforcing in this space when most of these companies have national markets? Well, don't take my word for it that everything is local. When in May of this year, Amazon was celebrating over 25 years of being open to independent sellers, it touted this statistic. Quote, "Today, more than 60% of sales in Amazon's store come from independent sellers, most of which are small and medium-sized businesses who are creating jobs, strengthening local economies, and bringing innovative products to customers worldwide, end quote. That definitely sounds like something that impacts local communities. Maybe in slightly different ways, depending on who those independent sellers are. But you know who would know those nuances? State attorneys general. State attorneys general also have a duty and are ascribed to enforce antitrust and consumer protection laws, and in doing so, protect their own residents and economies. And in some states, per statute, they're the only ones who may do so. Moving on to policy. Policymakers at state and local levels are considering whether to give state enforcers additional tools to address harms that may come from the use of technology. My predecessor at the NAG Antitrust Task Force Chair, Gwendolyn Cooley, will have a useful article on this topic published in the ABA Antitrust magazine in its next issue. She uses recent decisions analyzing the use of algorithmic pricing models in various industries and potential guidelines. She makes suggestions for what lawmakers and businesses may be able to glean for drafting appropriate and useful policy. She points out that the imprecise use of the term algorithmic pricing, when perhaps one is actually referring to artificial intelligence, is potentially harmful if that impreciseness reaches its way into law. That's when both businesses and enforcers could be on the same side in working to avoid a law that is nearly impossible to interpret. Not surprisingly, given the recitation of the number of states engaged in litigation regarding the use of algorithmic pricing tools in rental markets, that is the fastest growing area of laws and city ordinances. And I'm sure our first panel will provide more detail on the legislation. I will just note that as states are little labs of democracy, cities are even littler labs of democracy. And we have a handful of cities that have passed prohibitions on landlord usage of an algorithmic pricing product in housing. San Francisco's ordinance will celebrate its first year anniversary this month. Philadelphia, Berkeley, California, and Minneapolis, Minnesota, where I live, have similar ordinances take effect in the early part of this year. How those ordinances will work and if they are effective in ways intended could influence other policymakers. And on the topic of today's second panel, the outlook for surveillance pricing law, which includes discussion of state and municipal level policy, is for good reason. It is another hot topic for legislators. Consumers may like loyalty programs or personalized discounts, but they probably don't want to be discriminated against based on their income level or marital status. Legislation that threads the needle is challenging and requires significant effort. But consider one near constant: who the state legislators might be giving the power to enforce surveillance pricing type laws to. Most likely, at a minimum, state attorneys general. And that can frankly be said for most state bills being considered in the tech space. For example, the third panel today covering anticipated trends for the data broker industry and enforcement, including regulatory actions aimed at increasing transparency and accountability, may also come back to state enforcers. The New York Attorney General's office is poised to enforce a law pending the outcome of a lawsuit that requires that, quote, any entity that sets the price of a specific good or service using personalized algorithmic pricing shall include with such statement, display, image, offer, or announcement a clear and conspicuous disclosure that states, all caps, this price was set by an algorithm using your personal data. The outcome of the pending litigation brought by the National Retail Federation on First Amendment issues will inform state legislatures also interested in identifying ways that companies' use of individuals' personal data can be more transparent. States are eager to retain the ability to have their state legislatures pass laws that enhance the existing tools for addressing the tech industry and the use of technology in a variety of areas. 40 state attorneys general sent a letter opposing the inclusion of a moratorium on state-level AI regulation that was in an earlier version of a federal budget bill earlier this year. the letter identifies that the types of laws already in effect in states, in addition to those that I've already mentioned, include those designed to protect against AI-generated explicit material, prohibit deepfakes designed to mislead voters and consumers, preventing spam, phone calls, and texts, requiring basic disclosures when consumers are interacting with specific kinds of AI, and ensuring identity protection for endorsements and other AI-generated content. The letter also highlights that 20 states have enacted comprehensive data privacy legislation, with the overwhelming majority including provisions that give consumers the right to opt out of specific kinds of consequential automated decision-making and require risk assessments before a business can use high-risk automated profiling. While I cannot predict the future, I can tell you that a general rule of thumb that applies to state attorneys general, where they tend to focus on many of the consumer protection enforcement efforts, including antitrust, is on budgetary issues, housing, healthcare, and food. And I can tell you that state legislatures also focus on this. They not only hear from their constituents, but have budgets, state budgets that they have to pass that include safety net programs that aim to fill gaps when there is an inability to cover the cost of housing, healthcare, and food. So if they get wind of a tech tool that might be making consumer access to one of those unfair, they will likely target it. So I will conclude by saying that the way we look at tech has evolved and continues to evolve, and conferences like this one are so important to provide a forum for bright minds to discuss and ponder the many challenges today, and then go out and take on those many challenges tomorrow. State attorneys general are ready. Are you?
We have time for 1 or 2 questions from the audience. Anybody have questions?
You mentioned budgets as an issue. It's been in the news. There are big budget fights between the federal government and the states. Budgets seem to be strapped at the state level. What is the budget outlook for resources for state AGs to do antitrust, this type of work?
So what I can say anecdotally, because we just had our NAG antitrust fall conference for state enforcers, and I do see that in the last, say, 3 years, that state attorneys general have prioritized antitrust, and they have added people to their antitrust and consumer protection teams. Whereas when I started in state enforcement 5 years ago, there may have been one person who was wearing the consumer protection, the charities, and the antitrust hat, and they only have to wear one hat now instead of 3, and others have increased their numbers. So I think that's good, but I don't know now going forward where we sit today if that growth will continue or if we will stay where we are for now.
Any other questions? All right, one last question, and then we'll go on to the first panel. Thank you.
What are the politics of working with other state AGs like? We do a lot of federal policy, and there's there are factions in the Democratic Party that are very pro-tech and others that are very critical. And the Republican Party, there are probably even more factions, but there is this kind of, I don't know what you want to call it, the new right, where they're saying they have concerns about concentrated economic power, just like they have concerns with concentrated government power. What's it like in the states working with state AGs? Is it partisan, nonpartisan? Would love to get your sense of that.
I think at the staff level at state AG's offices, it's very collegial and supportive, and we don't look at each other as from a Democratic state or a Republican state. We just generally know that decisions ultimately come from our front offices, but we understand that and focus on the areas where we have commonalities. But we aren't going to have hard feelings if certain states join one matter and don't join another matter. We're very supportive, I think, generally of each other, even if we aren't in a particular case. We try to keep up and support each other in those ways. I think that, when it came to, the merger guidelines or other things, states try to come together and reach consensus, but when they can't, they understand that there may be differing areas of opinion. But I think in antitrust, we really try to focus on the areas that we can work together on. And sometimes that's hard. Each state votes with their feet. So it's not necessarily like a private litigation where someone is appointed lead counsel and gets to make all the decisions. There is no one state that gets to make all the decisions. They have to reach consensus every single time. There's a strategy decision. And we think that it's hard work, but it ultimately results in a better decision each time those decisions are being made.